The law of partnership is contained in the Indian Partnership Act 1932, which came into force on 1st October 1932. The Act is substantially based on the English law related to partnership. The main principles are the same, but at places certain alterations have been made to adapt the law to the conditions prevailing in India. The Partnership Act is only a supplying legislation in a sense that a contract of partnership is a special contract, and where the Partnership Act is silent on any point, the general principles of law of contract apply. Partnership is the relation between the persons who have agreed to share the profits of a business carried on by all or any of them acting for all. This definition is enumerated in Section 4 of the Partnership Act. Persons who have entered into a partnership with one another are called individually as partners and collectively as a firm. The new Companies Act of 2013 has prescribed the maximum number of members should not be more than 100 in case of a partnership concerning banking business and 200 concerning other businesses. The partnership relation is one of contractual nature. It arises from contract and not from status. Agreement between the partners is the basis of this contract. The agreement agrees to the notion of contractual theory and therefore can be expressed or even implied. Partnership agreement, like any other contract, must have all the essential elements of a valid contract. A partnership can be formed only for the purpose of carrying on some business. The business to be carried on by the firm must be legal. The object of partnership must be to make profit. Profit means net profit, and that must be distributed among the partners on the agreed terms of the partnership. The business of partnership may be carried on by all the partners or any of them acting for all. A partner is both an agent in the sense that he can bind by his acts the other partners, and the principal in the sense that he can bind by the acts of the other partner.